But it is there, my lord. I can assure also, my lord, I've seen. Can you see? There is no delay in filing public interest litigations. Very interesting. Very significant. Why that was done?
Where did you get public interest litigation? Yes or no?
Page the paragraph kota?
18.
Paragraph 18. Last. There is no delay. It starts with that. Have you got it, my lord? 5 years is no factor. There is no delay. There is no delay. And in filing the public interest litigation, and the corruption is still continuing and now single happens. It's very funny. If it is a public interest litigations, the single judge cannot entertain the matter. And person having some interest in the lease of the litigations, he cannot approach.
Yes.
So, my lord, he has got no locus standi to challenge. If he either or, if he says these are public interest litigations, he cannot challenge. If it is a public litigation, single bench cannot hear the matter. So it is his statement. And if I am not wrong, it is to my knowledge. Thank you very much. So this is really shocking, unfortunately. First, enormous delay. Yes, as I've seen in so many cases, Supreme Court says, it doesn't matter. If I find there is a substance, we can interfere. But right from the beginning, he never approached the court with a clear mind, not only clear mind. It's equitable, really. There's a doubt about it. So this approach is totally illegal. And being failed, he just approached. Supreme Court has condemned that. I'll not take much time. I'll not disturb your lordship. I'll only tired. Argument, factual aspect. And I'll not enter into the factor because I was not a party there. Why should I? Can you see one judgment? My lord knows it. 2017 Supreme Court cases. I hand over all those have been compiled. And 5 paragraphs note. 2017. Though I'll file in compile. Morgala Shunte Pachis, that is my discredit.
79 Supreme Court.
I remember in one case, I was arguing in Kundu number 18. You just in Mukula Mugaji, just. If candidate, paragraph 4 to 12, I'm just spreading the white notes, which is normally not do, but if candidate participate in selection process, that is got it, my lord. It cannot subsequently turn around and question selection process or constitution of selection committee only because he was not selected. On fact, hence, I could err in ignoring well-settled principle of law by rejecting objections to maintain the repetitions. So after being failed, he participated in the thing. I could understand that, well, he has got no interest, but for the greater interest of the state and the public, he approached the public interest litigations. That means if anything mischief is done, it will continue. No. Any other person come and say, here is the wrong, please correct it. But he is not, they are not permitted to approach it. Because suppose if they are selected, they will accept everything. Oh, everything is all right. Because they could not succeed, they jump up after 5 years, they woke up on the slumber and they came with an unclean end. And very unfortunate, they challenge the selection process. Good but indifferent. I'm not entering in the merit. So this is my first point, my lord. He has no legal right. This is a vital aspect.
Confused.
Certainly, my lord can ask Mr. Managing, we are here, we are hearing you. Enter the merit. No. Supreme Court says, if it is found that, well, person against whom the order is passed, he is not made a party, order should be set aside. Very short judgment, very well, compact. That is reported in, I assure Lordship, my lord, I will not take much time, only question of law. I really like this judgment. Follow me as this. I'm very happy with it.
When you are on the other side, you will not like the judge.
Why not? We don't need. Just me. No, no, to delay no. It's a very interesting judgment, very short judgment, one track. I've seen only two honorable judges of the Supreme Court. They delivered this one, Justice G. and Justice also then was. And this one. Can't able to come at page. I'm very happy with that. No, 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 judgment.
Yes, sir.
Yes. Kindly take trouble. There were reported in 1996 three Supreme Court cases. I'll hand over the judgment.
1996.
1996. Three Supreme Court cases, 587.
Paragraph.
There's one paragraph, very interesting. Very short judgment. I'm reading. Why I'm referring, I come. Leave granted, we have heard the learned counsel of the both right. It appears that the appointment of the first respondent was annulled by the proceeding that is such and such. Consequently, see such and such, learned counsel for the first respondent states that his client has lost interest. Very clever. While not clever in the morning, I wanted to withdraw for other reasons. But here, not that cleverly. Honestly, I must really confess. But here, is a very cleverly. Oh,
Yes. Unless you had caught on the wrong foot, you wouldn't have done. But Mr. Banerjee is there. He will not leave you.
She's a face call of action. As anything, he is not contesting the matter. It is not in dispute, which is very interesting, that the appellant was not a party to the impugned order dated 15 June 1993, made on OA number sunset by the Tamil Nadu Administrative Tribunal Madras, without being included as a party. Appointment of Thomas was annulled by the impugned order. The tribunal, therefore, has committed grave error of law in upsetting his appointment when law was not made, when he was not made a party. The impugned order is set aside as regards the appellant. As regards the appellant. So that's why I am not taking any risks or anything to enter the merit. Why should I? Supreme Court says, since you have not been able to the party, and here you only apply in case of 250 petitioners. I am not speaking for the others. Other, I give the judgment. Supreme Court could have said, all right, I'm setting aside, I go back, we are directing the authority to consider once again. Supreme Court said, no. It is set aside. It can't stand in the eye of law. So that's why what I'm on, since we have not been included as a party, and no opportunity is given, it's a fundamental principle. It was passed, and I've lost my job. What's wrong I've committed? I'm asking myself. Is it found by the court that, well, I'm a bad man, I adopted wrong practice, illegal practice? I don't understood. No adjudication is being, even my district, nobody called for test. Nobody was examining. Malda, I'm from Malda, so totally.
But you are from one district. All your petitioners are from one district.
Yes, Malda. Yes, Malda. Malda was never called. No person was invited. All I want to examine. I cannot say court cannot do that. But under what circumstances, I will not answer. I will not leave the bed.
Thank you.
So, my lord, what I am on, my lord, law doesn't mean to be mere theoretical abstraction. It is an instrument to justice. Is it justice what I have got? Is it really a justice? What wrong I have committed? I am repeating this again. Another thing is this, my lord. My lord. Because it is not a public utility litigations, court has got its own restrictions. Because on the basis of postcard, my lord, even Justice Bhagavati entertained no problem. When my lord is seated at the public litigation bench, I say, no, Mr. Manager, I've got the information. That is enough. After the public litigations. We are here to protect the interest of the public as a whole and the interest of the state also. This is not a public litigations. So whatever we have said as a petitioner, court certainly will restrict himself within that. There is a Supreme Court judgment to that effect.
On the ground,
Court cannot travel beyond that pleadings. Because what is the distinction between? Yes, I'll give you the reference, my lord.
it has been argued, Mr. Manager.
Yes, if it is argued, it's all right. No, but why this judgment, particular judgment was cited or not, I do not know. Well, that is reported in, if it is cited, I do not know, 2003, 8 Supreme Court cases. Page 40.
40.
40. If it is cited earlier, that's a different thing.
In the absence of pleadings, you cannot argue.
That's a very, why? Just in one of the analogy that you cite, my lord, very beautiful distinction between the plaint and the writ petitions. Now, let me just finish it, my lord. Article 23, practice and procedure. Issue in question only to be considered. Disposal of the case on a point not raised by the parties and omission to decide the question raised held improper. So if I raise something, but it is not adjudicated, that is improper. If I do not raise, but court took the responsibility to decide, that is not improper. Here also, my lord, from the writ petition, absolutely vague. I am sure it is not drafted either Mr. Bhattacharya or Shamim. Some junior children, they thought this is enough. They took a chance. After 5 years, all right, let us take a chance. Now they are trying to build something without having any foundations. This is really unfortunate. Why do you have said that, my dear friend? Why court will take the burden? Today I cannot bring so many things and put it on your shoulder. Kindly, it's like sometimes in the lower court it is like, आपने तो सर जाने judgment they can नहीं भाई, how is it? It's all burden on the court. So this is the case, my lord, where I wonder what this judgment, my lord. Actually, it is improper. It should not be encouraged. Now, my lord, this is another judgment. I want to say something.
Yes.
Asking me something, my lord. No. Which is reported in 1984 Supreme Court cases 534. 88.
84.
88.
88 Supreme Court cases.
88 4 Supreme Court cases. 534.
534
Yes, my lord.
on the proposition.
I'm reading, my lord. As has been already noticed,
that on 25th September 2023, my clients went to the Supreme Court, and when the Supreme Court panel sent us back to this honorable court. 25th September 2023.
You went directly to the Supreme Court.
Division bench ছিলাম, division bench বলেছিল single bench যাবে, ছিল ওটা থেকে চ্যালেঞ্জ করে আমরা Supreme Court. Well, what happened was this: we came to the division bench first, and the appellate bench was pleased to direct us to go back to the trial court, the single bench. So against that, we went to the Supreme Court. We said that we don't want to go to the learned single judge. So against that, we went to the Supreme Court, And the Supreme Court said that you go before the division bench. And that is, my lord, an order dated 25th September 2023. And my lord, after that order was passed, on the 15th September 2024, we preferred this appeal.
So please give us that order of
Yes.
25th
My lord,
September.
this is a. But I'm sorry, but I've got only one copy. May I hand up to your lordship?
Doesn't
If
matter.
the division bench order is this, 15 June 2023, then my lord, Supreme Court order 25th September 2023.
This is 19. Oh,
এখানে আমাদের কজন রয়েছে প্যারা টিচার 500
he ordered the against just we are clarifying
লর্ডশিপ
this is judgment of 12th May 2023.
correct.
So far, the councils who have argued, they were not parties to this. We have heard Mr.
I think we should, the Advocate General first.
We heard the board, then Mr. Bandyopadhyay, then Mr. Mithra.
Correct.
So, in respect of Mr. Bandyopadhyay and Mr. Mitra's client, they were parties to court. This after this order was first order was passed by Justice Talukdar. No.
Yes.
In that you preferred leave to appeal, or that was a this was an appeal preferred by the board.
This, the main appeal has been preferred by the court. We have obtained leave, my lord. 589 para teachers have obtained leave of this honorable court on 15th September 2024 to prefer this appeal.
15 September order is with you.
66.
It's 25th September.
আমার ম্যাথমেটিক্সটাই আমরা করছি। But have I been able to make clear, my lord? This is some amount of confusion is there because there has been movement to and fro.
So that is why if we are the judgment was 12th of May 2020.
Correct.
Against that, the appeal was preferred by the board. Only by the board.
Board, along with Malad, 2-3 groups, Malad preferred Malad leave to appeal before Justice Talukdar.
And they were not para teachers.
So there was any leave to appeal by the para teachers also on that date.
No, on that day, there was no appeal from the para teacher. After the order of Justice Talukdar, Malad interim order, just after the order, Malad, the next day, some of the candidates from the para teacher preferred an appeal,
Right.
whereby the division bench directed them to go before the single. The first order by Justice Talukdar, when the appeal
First order of Justice Talukdar was staying the appointment, but saying that the examination procedure was continued.
absolutely.
Now, after that order, agreed by that, again one group went to Supreme Court.
Both
The board as well
as the other.
who were before Justice Talukdar.
Yes.
Now the Supreme Court said that no, we are staying the fresh appointment also. Now, did the para teachers add themselves or pray for leave to appeal subsequent to that?
No.
So where is the order of the Supreme Court was of 7th of September, na? That
July.
7th of July.
Main order.
We said, why don't you give us a and handed over loose copies? I want a bundle of that so that we can maintain the track. If you can do so, otherwise.
I think that will be helpful.
Immediate order I don't do.
তুমি
Plus, I want to know there are 44 appeals, na? So till now we have here, this is the board's appeal. He has argued. We have heard Mr. Mithra today. We will hear it. But no, there are many leave to appeal applications. We want to know what were the orders passed.
I'll do.
Yes, Mr. Mithra.
Well, uh, if I may just give you Lordship a short introduction, that para teachers are contractual teachers engaged in different government schools across the state. Well, under Paschim Bongo Sarva Shiksha Mission, and well, they are imparting education to students, and they are discharging well at par with the assistant teachers, but at a much lower salary. So, well, the para teachers are appointed almost like my lord, a sort of ancillary to the regular teachers for the purpose of education in the primary section. Now, my lord, as I told you, Lordship, in the total vacancy, being my lord 42,949, under the rules, under the law, my lord, 10% has to be, my lord, kept vacant for the para teachers. And that was there, my lord, we came in. This appeal, which your lordship is hearing, 966 of 2024-23, well, that is an appeal by 585 para teachers.
Yes.
Well, I will request your lordship, my lord, when they were, my lord, second one, the two rules I shall refer your lordship to. My lord, kindly take, my lord, the 2nd March 2016 notification. As per this notification, 10% of the existing vacant posts shall be filled up by the para teachers.
No paperwork in this? In your appeal, there is no paperwork?
আমাদের এটা কি
Final by handed over. It is there. Two files. All rules are there. All.
You are placing which rule, Mr.
Yes, well, I shall. Well, I have been told, my lord, that that stay application and, my lord, the memorandum of appeal on which, my lord, this leave has been granted, that is there before your lordship.
Your rules are annexed to that?
Your rules, no, my lord, not in my paper.
So which rule are you placing, Mr.
I am, my lord, 2nd March 2016. This is, my lord, West Bengal Primary School Teachers Recruitment Rules 2016.
Yes.
There are two sets of rules.
Yes, 2nd March 2016.
And this is known as West Bengal Primary School Teachers Recruitment Rules 2016.
Yes.
Now, my lord, kindly come to straight away first to Rule 6. Kindly come to Rule 6.
Yes.
I am not troubling your lordship with sub-rule 1 and sub-rule 2, these qualifications. But kindly come to Rule 3, sub-rule 3.
Yes.
In the matter of appointment, priority shall be given to those eligible candidates who possess the minimum qualifications as specified by the National Council of Teachers Education and MHRD, and thereafter the eligible candidates with the relaxed qualification specified by MHRD may be considered. And if candidates with relaxed qualifications are considered as teachers, such teachers under the relaxed qualification norm shall be appointed with an undertaking to acquire the minimum qualifications specified in National Council of Teachers Education within a period of 2 years from the date of appointment. I am not troubling your lordship. The other notes, kindly come to note 7, with which I am concerned.
This qualification you completed.
Yes. Kindly come to note 7.
Yes.
The state government may, by notification in the official gazette, earmark. Kindly, my lord, note the words earmark, because this will recur more than once. Earmark up to 10% of the total post for the candidates belonging to para teachers without disturbing the 100-point roster as notified by the state government from time to time, in such manner as may be mentioned in such notification. Then, my lord, the proviso, provided that the qualification of such categories of candidates shall be the same as mentioned in these rules. Then further proviso, provided further that notwithstanding anything contained in this rule, the upper age limit of the candidates to be appointed as teachers by earmarking 10% of the total post shall be relaxable up to the period of service rendered by such candidate, subject to the maximum of 50 years, as on the 1st of January of the year of advertisement. Now, my lord, so this is, my lord, the rule under which 10% has been kept reserved for the para teachers. And that is why I submitted to your lordship, out of this 42,000, 10% is 4,000 and odd. That is the number of para teachers which who are to be appointed. Now, my lord, kindly come to Rule 8, Sub-Rule 5. I shall take your lordship to other rules afterwards. Rule 5. This should be at page 6 of this rules. And, so far as Rule 8 is concerned, that is the procedure for selection. In this manner, Rule 5, Sub-Rule 5 is, the selection committee shall prepare separate council-wise panels as per the procedure below. Firstly, the selection committee shall segregate all eligible candidates applying for earmarked vacancies as mentioned in Note 7 to Rule 6 from other successful candidates. Therefore, my lord, kindly note A is the
10%.
selection committee, 10% will have to be earmarked. Then secondly, the selection committee shall prepare the following panels for the successful candidates who have applied for non-earmarked vacancies. I am not troubling your lordship in this. Kindly come to the Note 2 under B. Separate sets of panels for all selected candidates applying for earmarked posts, as mentioned in Note 7 to Rule 6, shall be prepared in accordance with the procedure mentioned in Clause I to I4, IV of Rule Sub-Rule B. So, my lord, insofar as the para-teachers are concerned, 10% are to be separately treated, and separate sets of panels will have to be prepared for these earmarked posts, applying, my lord, the procedure mentioned in Clause I to IV. Your lordship has got that? This is, my lord, Note 2, or under subsection Sub-Rule 5 of Rule 8.
So 8.5 is exclusively for para teachers.
8.5, not really. 8.5A is separately for para teachers, but B, 5B, is in respect of all the rest. That means non-earmarked. That is why I showed to your lordship that insofar as 5B is concerned,
So non-earmarked vacancy, you are meaning to say that apart from para teacher.
earmarked is apart from earmarked as the para teachers. And that is, my lord, as per the, I have shown to your lordship, this Note 7 of Rule 6. And that is why throughout your lordship will please to note that para teachers have been treated separately. That is Note 2. Separate sets of panels for all selected candidates applying for earmarked posts, that is, my lord, para teachers post, as mentioned in Note 7 to Rule 6, shall be prepared in accordance with procedure mentioned in clauses I to IV of Sub-Rule B.
So
Now, my lord,
the both are applicable.
yes.
This formation of panel and segregation as appearing in respect of primary teachers are also for para teachers.
Yes. The same criteria will be applied in respect of both. Yes. In separate panel, my lord, 10% will have to be kept separate. And in respect of this 10% also, the same thing will apply.
Para teacher appointment was not challenged. But his appointment was
They were not challenged, but unfortunately, we have been put into the same category and had been thrown out.
12th of May judgment. It says in paragraph 21, in such circumstances, appointment of all primary teachers is cancelled.
All primary teachers. So, in that
You
one,
will come within the primary teacher. Then you are a para teacher.
no. We are primary teachers.
Against 10% earmarks.
Yes, we are
The
primary teachers.
conditions of service are different. You are contractual.
I don't think so.
You will continue till 60 years of age.
50 years.
50 years.
No, I think it's extendable. Of the primary teachers, I am not being able to explain to your lordship. Of the primary teachers, 10% has been kept apart. And this 10% is only for the para teachers. So this 10%, one has to wait until it is fulfilled by the para teachers. Non-para teachers will not be able to come into the category, if I have understood this system. So, insofar as we are concerned, now, we have been put into the same, what should I say, same basket.
Any one of the writ petitioners was a para teacher?
No. 149 writ petitioners, none of them para teachers.
All primary teachers?
Yes, we came into the picture only in at the appeal stage. After the order had been passed, and we have been, we found that we found one fine morning that we are on the street. We don't have any employment.
Yes.
Now, kindly take, your lordship has been pleased to see the procedure mentioned in clauses I to I4 in sub-rule B.
Mr. Mitra, just interruption. Your selection has not been challenged, that you have not followed, that they said no aptitude test was there.
So that is what I wanted to show to your lordship. The learned judge went wrong there also.
No, you appeared in aptitude test.
No, I don't have to appear. My teaching experience is that is what
You find that
this is the rule of this is I showed to your lordship 2nd March 2016 rule. Now kindly take 23rd September 2016 rule. Is it there before your lordship? Otherwise, I shall hand up to your lordship. 23rd September 2016. This is by way of amendment of the March rule.
by which that Rule 7 was amended. Rule 7 was amended.
Rule 7, various amendments took place, including procedure for selection of Rule 8. And that is what is important.
Mr. Biswas, you just give us
I'm just
I think it will be easier for a lordship if these rules should be kept separate.
So, 2nd of March was the advertisement. Second rule. Advertisement was September 19th.
September 2016. 26 September 2016.
And my lord, by that time, 23rd September 2016, my lord, amendment has come into existence. This is very important. My lord, before your lordship goes into the amendment, kindly, my lord, come to rule of that March rules, Rule 8, Sub-Rule 3.
My lord, your lordship will find, my lord, in the paper, in the final binding, my lord, the index was also there, my lord, your lordship will find, my lord,
September rule that
my lord,
এটা তো সেকেন্ড ভলিউমটা এটাই দেখাচ্ছে হচ্ছে কম্পাউন্ড
kindly come back once more to the Rule 8. Rule 8, Sub-Rule 3 of the March rule, the earlier rule.
Rule 8 you showed us just now. No, Rule 8, the procedure for selection.
Procedure for selection. Procedure for selection. Kindly come to Sub-Rule 3. Academic qualifications, training, performance in the TET, extracurricular activities and performance in viva voce test or interview and aptitude test shall be computed in the manner as mentioned in the table A below. And here, my lord, your lordship will see there is a table like this, and there your lordship sees extracurricular activities 5, viva voce or interview 5, aptitude test 5. Your lordship has got that. Now your lordship take the new rule, the subsequent rule, amendment of 2017, of September 2016.
So amendment was subsequent to advertisement.
No, it is before that.
The advertisement was
On
19
26 September. 26 September. And this is 23rd September.
Yes, sir.
Your board appeal, take your paper, we were shown this.
Yes, ma'am.
In your paper, page 100,
120. 120 is the
111 is the recruitment rule.
and my lord, 120 your lordship. 26 September, your lordship will find
At
my lord.
left hand side top.
Left hand side top.
26 September.
26.
Achha, this amendment came prior to that.
Yes, 23rd September, 3 days prior to that.
This amendment is not in your paper book, 23rd September. Yes,
This was not before the learned trial judge, and he did not have the occasion to consider this. So, my lord, kindly take this. My lord, your lordship got the notification. Notification, right? Just look at it.
notification, which one? 26 September?
Of 23rd September, there is a notification, and thereafter the rules.
Yes, 23rd.
Yes. My lord, kindly see, my lord, the second paragraph of this.
Oh, where is the rule after amendment or next?
My lord, this is just before this notification is prior. There are 2 notifications of 23rd September. One notification is, my lord,
656, 657.
My lord, this is this that kindly come to the second paragraph. This particular notification is specifically, my lord, for the purpose of protecting the interests of the parent teachers. Kindly see second sentence. Now, therefore, the governor is pleased hereby to direct that during the forthcoming recruitment of teachers for primary schools, 10% of the existing vacant posts shall be filled.
657.
657. 657. I am placing this first, and then, my lord, I am coming to 656. This is notification dated number 657 of the same date. Second paragraph is, now therefore the governor is pleased hereby to direct that during the forthcoming recruitment of teachers for primary schools, 10% of the existing vacant posts shall be filled up by the parent teachers serving at present at various primary schools in the state. Then, my lord, kindly come to the penultimate paragraph on this page. The governor is further pleased to direct that the Commissioner of School Education, West Bengal, shall earmark, and this is the earmark, the vacancies for the para-teachers while compiling vacancies as per sub-rule 2 of Rule 4 of the said rules. Now, my lord, then your lordship will please to come to the notification of the same date, notification number 656. And this notification is by way of amendment. Amending, my lord, the earlier rule of, my lord, March. My lord, I don't want to trouble your lordship. Kindly come to, a few of these amendments will be required. Kindly come to the second page of this. Rule 7, which I just now placed before lordship, that has been amended in this notification.
Yes.
Kindly come to, first your lordship kindly comes to sub-rule 4 in the amendment. for sub-rule 3, my lord, kindly see sub-rule 3 I just now placed before your lordship.
That is rule 7. Rule 7.
Rules, it's this thing, my lord, kindly see. Rule 8. Kindly come first of all, come to rule 8, I come to rule 7 afterwards. Rule 8, that is, my lord, in the notification 4, paragraph 4.
So in omission of the chart,
Yes.
it was placed academic qualification, training, performance in TET, extracurricular, vivacy, or interview and aptitude, or teaching it.
In 555. Now, my lord, this has been replaced by, my lord, this amendment of 4, sub-rule 4 in rule 8. In sub-rule 3, substitute the following sub-rule. Academic qualification, training, performance in TET, extracurricular activities, viva voce, or interview, and aptitude test, or, this is important, this has come in, or teaching experience in case of para-teachers. So aptitude test is no longer necessary for a para-teacher. And this is where the learned judge went wrong.
No, it is either or.
No.
Either it can be
No,
aptitude
well,
or it can be-
may I read it again? Interview and aptitude test, or teaching experience in case of para-teachers. It is aptitude test or teaching experience for the para-teachers. That is aptitude test for non-para teachers. But so far as para-teachers is concerned,
Oh, I see.
it is teaching experience.
And in the next clause, that aptitude
Yes.
test is omitted.
Your lordship sees this. In the amendment, serial number 7, their aptitude test A, B, teaching experience of para-teacher. So, my lord, really, my lord, if your lordship reads this whole thing together,
Come to the next one in sub-rule 3. In serial number 7 of table A, for the words, letters, figures, and brackets, aptitude test 5 marks, substitute the words, letters, figures.
aptitude test, then B is teaching experience of para-teacher.
So in respect of para teachers, there was
Only teaching experience, no aptitude test. This is made clear. The sentence in subparagraph 3 has been made clear in this box. So far as para-teachers is concerned, teaching experience only.
Yes.
So once para-teacher, then kindly read this along with the next page, note 5. This the learned judge did not consider at all.
Note 5. Yes.
No, sorry, note 6 on the next page. Note 6, marks of maximum 5 marks in serial number 7B of table A of this rule shall be awarded to para-teacher candidates in the following manner. Teaching experience, 5. So out of 10, 5 is teaching experience. Yes.
In respect of para teacher, there will be, everything will be same, even except substitution of aptitude by teaching experience. This is your argument.
Correct. And my lord,
Trial judge did not consider
at all.
ready.
My lord, this is one thing. Second thing is, kindly note, experience above 10 years, one gets 5 out of 5. This is the first one. Why I am saying so, now your lordship takes the impugned judgment. Kindly, my lord, take. Lordship will be pleased to come to straight away to paragraph. Your lordship will be pleased to come to paragraph 14. Page 11, internal page 11, paragraph 14. I am just demonstrating that these facts should have been brought before the court. Paragraph 14,
Throw just one.
well,
In the writ petition, there was no averment as regards para teachers, subject to correction.
correct.
no prayer for para teacher. In the judgment, 36,000, later 32,000 cancelled. What is appointment of 36,000 more or less candidates who were untrained at the time of recruitment 2016, conducted by the post in the post of primary teachers be cancelled.
Well, I am about the primary teachers. Of the primary teacher, there are two categories. Para teachers
For
and non-teachers.
definition of primary teacher in the
Your Lordship, kindly see the notification, it will be clear. Kindly take the notification, it itself will say.
in the rule, primary teacher is defined.
Yeah, bol.
Primary teacher defined.
Teacher को selection process हो रहा है ना.
Yes, Mr. Rahul, primary teacher defined.
Your Lordship sees this.
But because of two condition they are coming. Because of number 32,000 and untrained primary teacher. That is why the para teachers the group is coming.
Why a group is coming? How?
Because untrained primary teacher, number one, and second is 32,000. That is why they are coming within the zone
So
of.
as it is said 32,000, you are thinking that para teacher is included. That is your appreciation of the order.
That is their apprehension.
No, but where from did Mr. Mitro, you were under this phobia that your appointment has also gone?
That they are para teacher. They are primary teacher.
What was the definition of primary teacher? Head teacher, primary.
Well, kindly see the notification. It is applicable. Kindly see the notification. What is the notification? It is the West Bengal Primary School Teachers Recruitment Rules.
Where you are reading?
Well, this is the 2nd March 2016 notification. Whereas the draft notification to frame the West Bengal Primary School Teachers Recruitment Rules to 2016, published as required. And in this, my lord, the para teachers are also included. They are also primary teachers. And this particular rules are applicable.
Where from do we get it? They are primary teachers.
Well, this is
para teachers.
well, may I come back to you? Just like this. Well, kindly see this notification, 2nd March, your Lordship has got it. It is West Bengal Primary School Teachers Recruitment Rule. In this, my lord, kindly come to rule. I just now placed before Lordship. Kindly come to Rule 6. In Rule 6, my lord, Sub-Rule 3.
That is for.
Kindly see Note 7. This is specifically saying, provided further that notwithstanding anything contained in this rule, the upper age limit of the candidates to be approved. The state government may, by notification in the official gazette, earmark up to 10% of the total posts for the candidates belonging to para teachers without disturbing 100-point roster. So, my lord, what is happening is this, in the matter of selection.
This means the total post of candidates.
Yes.
Belonging to para teachers.
Candidates for primary teachers, for the post of primary teachers.
Wait, that line is not there.
But this is the rule. These rules are only for primary teachers. These are rules, my lord, West Bengal rules for teachers, primary school teachers.
Now kindly come to the definition of teacher. Rule 2O.
Rule 2.4.
Teacher means a person who holds a teaching post in primary school or in a junior basic on a regular and whole-time basis and is paid fully or partly from the funds of control of the state in India.
Right, right.
You do not come within 2O.
Well, I wish I could, I did not.
That is, we are
I wish I did not. But it seems, my lord,
very good that under the same notification.
this has also been made clear. This has also been made clear by the subsequent amendment. Kindly come to the amendment. The opening words. Notification 657. Bosho. Number 657. Whereas in terms of Note 7, after Sub-Rule 3 of Rule 6 of the West Bengal Primary School Teachers Recruitment Rules 2016.
Where you are reading?
My lord, this is, my lord, the amendment notification of 23rd September, number 657. 657, not the 656. Oh, that is there, my lord, in front. The first page. Your lordship can mark it, my lord. 657 is a short notification, just one page.
Yes, yes.
This itself make it clear.
Yes.
Second paragraph, see. Now, therefore, the governor is pleased hereby. Well, kindly, let me read this. Whereas in terms of note 7, after sub-rule 3 of rule 6 of the West Bengal Primary School Teachers Recruitment Rules 2016, hereinafter referred to as the said rules, it has been specified that the state government may, by notification earmark, up to 10% of the vacant posts for the candidates belonging to para-teachers, vacant posts of primary teachers, belonging to para-teachers, without disturbing the 100-point roster as notified by the state government from time to time. In such manner may be mentioned in such notification to provide adequate representation of the para-teachers. This is the notification. September notification was brought into existence for the purpose of protection, or for the purpose of, my lord, for the purpose of laying down that 10% of the posts shall be filled up by the para-teachers. So these are primary teachers, 10% of the primary teachers' posts will be filled up by. This is what is being protected by this notification. And there, my lord, your lordship has been pleased to see that para-teachers, insofar as para-teachers are concerned, the teaching experience is required, aptitude test is not required. This is the alternative to this. For non-para teachers, aptitude test, but teaching experience in case of para teachers. Now, my lord, keeping this in mind, and I am showing your lordship, my lord, that insofar as teaching experience is concerned, note 6 of the September 2016 notification has specifically said that experience above 10 years, 5 marks, experience above 8 years, below 10 years is 4, experience above 6 years and below 8 years is 3, experience above 4 years and below 6 years is 2, and experience below 4 years is 1. That is how the marks is to be given. Now, keeping this in mind, kindly come to page 11. This is where, my lord, the learned judge went wrong, because, my lord, he did not take note of this, because it was not pointed out to his paragraph 14. After holding that there had been a large-scale corruption in the earlier paragraphs, extraneous factors, etc., the court had said this in para 14. Now I give example of a candidate before giving a table prepared from the document on record. That is page 121 booklet. This candidate has got 2.866 in TET out of 5, 1.462 in secondary out of 5, 3.050 in higher secondary out of 10, totaling 7.378. This is not in respect of any of, my lord, the persons, my lord, for whom I am appealing, but has awarded 9.50 marks in interview and aptitude test. Aptitude test was not taken out of 10, whose total score became 16.878 and thus became eligible for appointment as a primary school teacher. Huge number of such absurd awarding of marks has come to light through the said booklet prepared from the particulars published by the board. Now, pausing here for a moment, a list has been given. Well, none of these are para teachers, excepting, this is what I wanted to show to you, lordship, page 12, 1, 2, 3, 4, 5, 6, 6, 1 from the bottom of this list. This is the only candidate, only person, my lord, who is a para teacher, whose example has been given, and that too wrongly.
Which one? 6.
Sujan Kumar Bishas, 6th from the bottom. He is the only para teacher in this entire list. My lord, Mrs. Mitra has got that in the entire list, my lord, 6-1 from the bottom. And my lord, this has been said to be an absurd giving up marks. Sujan Kumar Bishas, in the, my lord, TET MP high secondary, not a bad number, 10.333. My lord, almost toward the top. And my lord, so far as this interview marks is concerned, 9.50. Now, out of 9.50, Your Lordship has been pleased to see 5 marks is for teaching experience. And that one, 5 marks for teaching experience, my lord, out of that 5 out of 5, if it is more than 10 years. This gentleman, my lord, has 14 years teaching experience. This Sujan Kumar Bishas has 10 years of
There is no possibility towards any other mark because it was specified. 5 years experience this much, 10 years this much.
So, my lord,
So aptitudes variation of marks does not
absolutely,
apply.
absolutely. This has not been taken note of by the learned judge. So, my lord, the judgment went wrong in this. My lord, really, I submit to your lordship that this is the whole story. And my lord, my submission is this, that perhaps if the learned judge had taken note of these particular provisions for the para teachers, perhaps this error would not have cropped in. The error is, my lord, glaring error. Because in the
Mr. Mitro, the relaxation granted by MHRD was for 2 years. By the memo, the other point which is being taken as regards training,
yes,
239 out of 4295 were trained para teacher. Remaining were untrained. At the beginning, you said that they have completed the training.
yes,
Now, they have completed the training after the
after an appointment.
No, but how can that be done? Relaxation was only for 6 months.
Lordship, kindly, my lord, again take that route. What happens is this,
Which rule, Your
so
Honor?
far as trained candidates are concerned, they are to be given preference. It is not that untrained candidates cannot be appointed. There, my lord, the learned judge went, so kindly, my lord, take this. Kindly, my lord, come to, my lord, clause. Yes. Kindly come to
Yes,
the
that is there.
proviso.
This will be given to the trained person.
Yes, proviso to rule 7, rule 8, sub rule 6, proviso. Or rather, I should say sub rule 7. Sub rule 7 of rule 8 at page 7 of these rules.
No, that we have seen. No, Mr. Ratul, where is that memo of the government that 2 years in your 870? Just 1 minute, Mr. The 2 years you have to complete that government memo.
পার্ট 4 অব্দি মালাট না ওইটা না বলছেন 2 বছরের মধ্যে কমপ্লিট করতে হবে
That government memo.
I'm just
To become the trained candidate. To become the trained candidate. I shall make my submissions on this, specific on this point. Kindly, my lord, I will request your lordship, my lord, kindly. That is why I say my entire submission will be on the rules, nothing but the rules. If your lordship comes to rule 8 of the March rules, procedure for selection, your lordship has got that. Kindly, my lord, come to.
Yes.
This will
I've
necessary.
seen that.
No, your lordship has not seen one very important thing. The procedure for selection, rule 8. That is at page 5. It's a longish rule. I am not troubling your lordship with this. Kindly, my lord, come to page 7 of that. Sub-rule 7 is about 10 lines from the top. Your lordship has got that? While preparing, that's how it's. I think your lordship should be having, my lord, these rules separately. I think that will be easier for your lordship. Otherwise, one rule here, another rule there.
It's 79 minutes.
এক second. Yes, finish it off, Mr.
Well, kindly come to rule 8, sub-rule 7, at page 7.
While preparing the panels.
Yes, while preparing the panel, this is what on the emphasis was given. While preparing the panels mentioned in sub-rule 5 and sub-rule 6 above, the selection committee shall first, note the words first, divide all the candidates who will be found eligible after the interview into 2 categories. trained and untrained. And thereafter, two separate sets of panels for each category shall be prepared, one for the trained candidates and the other for the untrained candidates. Then, notwithstanding anything contained in any of these rules, the empaneled trained candidate shall be absorbed first against the sanctioned vacancies, and thereafter, the untrained empaneled candidate shall be absorbed against the remaining vacancies. It is not that the untrained candidates are totally excluded. You first of all absorb the trained candidate and then you go for the untrained candidate. So, Malad, if there is an untrained candidate who had been absorbed after the trained candidates have been absorbed, then Malad, untrained candidate can Malad get trained during the in course of their service. Nothing wrong in that, and become trained candidate. But in the matter of appointment, I submit to your lordship, it does not make any difference. It makes difference in the sense that trained candidates will have the first preference. First of all, the vacant posts are to be filled up by the trained candidates. If there are sufficient vacant posts which are not filled up by the trained candidates, then the untrained candidates can come in also.
No, Mr. Mitra, that was not our, please come to Rule 6, Sub-Rule 3,
Rule 6, Sub-Rule 3.
59.
Our final binding, just hand over your lordship,
No, paper book ঠিক আছে 873 paper book.
6, Sub-Rule 3. Yes.
In case of, in the matter of
In the matter of appointment, this is the one. Priority shall be given to eligible candidates who possess the minimum qualifications as specified in the National Council for Teacher Education and MHRD, and thereafter, the eligible candidates with the relaxed qualifications specified by MHRD may be considered. And if candidates with relaxed qualification are considered as teachers, such teachers under the relaxed qualification norms shall be appointed with the undertaking to acquire the minimum qualification specified in the National Council of Teachers Education within a period of 2 years. But each of my candidates, each of the persons I am appearing for, they within 2 years after their appointment, they got their this training for this particular course. Now, my lord, this is something I submit to your lordship. Forget about what I am saying. I say that when you are determining the future of a person who has been appointed and coming to the conclusion that they should not have been appointed, in my very respectful submission, each candidate was entitled to have his worth decided by the court. If the court didn't have the time, then the court shouldn't have accepted the money, the matter. After all, my lord, this is no child's play. These persons have been working, and suddenly one fine morning they find they're on the street. The court has not made it clear that this particular judgment will not be applicable in respect of para teachers. So what is the position then? We are still in the dark. Are we? Are we covered by the judgment or are we not? The question that has fallen from your lordship, what is troubling your lordship, the suspicion, well, that suspicion is in my mind also. Well, this is my short submission before your lordship. I am submitting to your lordship, the court should have been much more introspective, much more careful in the matter. It should not have been done in this way. You give a notice to this person, put somebody in the box, ask questions.
You have accepted it, Mr. Mitra.
What have I accepted?
When the leave to appeal was preferred, you ought to have taken the specific ground.
I have taken the specific ground. I have taken all these grounds in my grounds of view. What I am submitting to your lordship, it is not from my brain book. This is what they have said. I am, my lord, only expressing to your lordship. Nothing more, nothing less.
You are wrong. You are saying that I in fact do not come within the contours of this judgment.
Yes.
So if that is your prayer, that ground ought to have been highlighted in special leave in your leave to appeal. Why you are bringing me within this?
My lord, your lordship kindly sees my
subject to correction. That ground is not there.
Your lordship will
and I do not come within that. I do not come within at all those 32,000 teachers whom you have said to be cancelled.
Well, let me check up. Maybe your lordship is right.
Your junior will check up, Mr. Mitra. You come to any other point if you have.
Well, they cannot ground that. Well, this I submitted. This is one. Last thing, my lord, I submit insofar as the rules are concerned. The learned judge has come to the conclusion, lordship will kindly come to that particular paragraph. Yes, selection committee টা কোথায় আছে? Paragraph 7. না, কোন paragraph এ বলেছেন? 16. Yes, well, there is one other thing I just want to touch with lordship. Paragraph 16 of the judgment, the full judgment.
Amendment was not taken into consideration.
Yes.
That is that he has argued.
So, my lord, I am not going to argue that. My lord, I just wind up my submission by saying this. Paragraph 17 is in my very respectful submission. Kindly do not take me amiss. If I am a bit, I shouldn't say, if I am a bit outspoken on this, your lordship, my lord, with your lordship's kindness, kindly excuse me. Paragraph 17. From the gross illegality in selection procedure in the recruitment exercise of 2016 conducted by the board, it is clear that the board and its officials, including its former president, who is now in custody after arrest by Enforcement Directorate for transaction of huge money in the recruitment procedure, conducted the whole affair like affair of a local club, and now it is gradually coming to light by investigation of Enforcement Directorate that jobs of primary school teachers were actually sold to some candidate who had the money to purchase employment. A corruption of this magnitude was never known in the state of West Bengal. The former education minister, the former president of the board, and a number of middlemen through whom the jobs were sold like a commodity are now behind the bars, and the CBI and ED investigation is being continued now in full swing. Then, my lord, kindly come to the next paragraph. It is a matter to be noted that board in its affidavit in opposition, while dealing with all pleadings of the petitioners, instead of addressing the allegation of corruption and illegalities in the recruitment process, raised some niceties of law and some principles of law. But however nice or however laudable these principles may be, this court, as a court of justice, will fail to deliver justice, knowing fully well that sense of justice is much above the sense of law. If the writ application is thrown out on such niceties of law, as this will mean that the name of preserving the law, the corruption would be protected, which a constitutional court can never do, keeping in mind the soul of our constitution and the constitutional conscience. I must say that in this recruitment scam, stinking rats are being smelled. Well, these are very strong language the learned judge has used. But what has been said here, I am criticizing this particular observation. It has nothing to do with the matter before the court. The court completely went outside it. I should say the court went out of control by making this observation. And an observation on the basis, mainly on the basis of media reports. The court should not have done it. When, my lord, the court is deciding the fate of these persons as to whether they should be kept or they should be not, it is absolutely necessary that, my lord, the grain should have been, my lord, separated from the chaff. This was not done. A few stray examples were taken and some persons were put in the box. And on the basis of their evidence, the fate of 40,000 people had been decided. Well, before I conclude, I would like to place before Lordship a judgment of Lord Denning. This is very instructive. I would request your lordship look in. I should tell your lordship what happened. In this particular case, which was before the Court of Appeal in London, the learned judge was a very, very erudite judge. He must not cross-examine the witness more than the counsel. So, my lord, according to the appellant, there was a miscarriage of justice. He went up in appeal. And see, my lord, what Lord Denning has said. Quoting from a judgment of the master of the rolls, Green. And my lord, I thought that perhaps I should bring it to your lordship's notice. It is instructive for all of us. And my lord, it is also, should be, my lord, something which your lordship should take note of. This is, my lord, Jones versus National Coal Board, reported in 1957 to Queen's Bench, page 55. I thought that this is very topical in view of, my lord, what is happening now all over. This was a case of trial. It is factually, it is different. Here, my lord, it was a case of trial, and the learned judge had come into the arena of dispute and started questions in cross-examination of the witness, which, my lord, had not been looked upon with great favor by the appeal court. My lord, kindly come to page 6. I will not trouble your lordship with the entirety of the judgment. I am just indicating to your lordship what had transpired in that. But the observations of the court are quite, my lord, instructive. Page 6, there are 8 pages. Your lordship has seen the.
Yes.
Kindly come to the second paragraph on that page. Nevertheless, your lordship has got
Yes.
page 6 of 8.
We are quite clear.
Here. Nevertheless, second paragraph. Nevertheless, we are quite clear, yes, that the interventions taken together were far more than they should have been. In the system of trial, which we have evolved in this country, the judge sits to hear and determine issues raised by the parties, not to conduct an investigation or examination on behalf of the society at large. As happens, society at large, as happens, we believe in some foreign countries. I hope it was not meant, India was not included in that. Even in England, however, a judge is not a mere umpire to answer questions. How is that? His object above all is to find out the truth and to do justice according to law. And in the daily pursuit of it, the advocate plays an honorable and necessary role. Was it not Lord Eldon, Lord Chancellor, who said in a notable passage that, then quote, truth is best discovered by powerful statement on both sides of the question. This is very important. Truth is best discovered by powerful statements on both sides of the question. Ex parte Lloyd. And Lord Green, Master of the Rolls, I was talking about this, who explains that justice is best done by a judge who holds the balance between the contending parties without himself taking a part in the disputations. If a judge, and said Lord Green, should himself conduct the examination of witnesses, then, quote, he, so to speak, descends into the arena and is liable to have his vision clouded by the dust of conflict. Then, my lord, kindly come to about 10 lines from the bottom. My lord, if the sentence starts with the after, my lord, Backpen and Harris has been quoted, then, my lord, the judge's part in all this. Your lordship has got that?
Yes.
The judge's part in all this is to hearken to the evidence, only himself asking questions of witnesses when it is necessary to clear up any point that has been overlooked or left obscure, to see that the advocates behave themselves seemingly and keep to the rules laid down by the law, to exclude the irrelevancies and discourage repetition, to make sure by wise intervention that he follows the points that the advocates are making and can assess the work and at the end make up his mind where the truth lies. If he goes beyond this, he drops the mantle of a judge and assumes the role of an advocate. And the change does not become him well. Lord Chancellor Bacon spoke right when he said that patience and gravity of hearing is an essential part of justice, and an over-speaking judge is no well-tuned symbol. Unquote. Such are our standards. They are set so high that we cannot hope to attain them all the time. In the very pursuit of justice, our keenness may outrun our sureness, and we may trip and fall. That is what has happened here. A judge of acute perception, acknowledged learning, and actuated by the best of motives, has nevertheless himself intervened so much in the conduct of the case that one of the parties, nay, each of them, has come away complaining that he was not able properly to put his case. And these complaints are, we think, justified. My lord, very loud and clear the judgment has been said. How a judge should behave, my lord, in a court of law. Well, I cannot put my case higher than this. I will submit to your lordship that in view of paragraph 16, the learned judges, this judgment should not be sustained. The learned judge was influenced by outside consideration, which were not relevant, not germane to the issue. But I respectfully submit to your lordship that the order cannot be sustained. These are my submissions.
Thank you.
So, for my lord, I am concerned, my lord, I have also an appeal in favor of the para teachers. That, my lord,
Anything to add, Mr.?
my lord, I have prepared a very 3 pages notes if your lordship consider that. Just to keep up.
You are in which matter, Mr.?
My lord, mat number 1547.
Matt?
Mat number 1547 of 2023. Item number
2023.
Item number 58.
1547 of 2023.
Serial. Well, just my lord, I place it your losses. This little notes, then your losses.
Yes.
Para teacher. No, my lord, the appellants.
Mr. Sannal, if you can tell us the points which have been left out so that we can.
Well, I don't think left out only your losses. If your losses have any confusion regarding how the para teachers come into the picture of this. Well, that's one of the only thing I think. Your losses I just place it. I think your losses get.
ওইটার সাথে রাখো এটা না মেট 966 এর সাথে জয়ন্ত মিত্র চিঠি ঠিক আছে না না ওটা দিতে হবে তুমি আমাকে
The appellants applied for recruitment para teacher against 10% earmarked vacancies of para teachers. This is wrong for recruitment, not para teachers, your lordships. For recruitment against 10% vacancies, 4295. Now 4295 means total vacancies 42,000. Para teachers in the recruitment process of 2016, as they all had been working as para teacher in primary schools. But up to 2010, para teachers were recruited and they had been continuing as the lawsuit and submitted on the contractual basis. Now, by virtue of the amendment of the rules, against 10% vacancies were earmarked for those para teachers for recruitment.
No, that is why I was saying that it is contractual, but you said no.
Not contractual, para teachers were contractual, but when I got appointment as primary teachers, that's not contractual. That's para teacher, primary teachers.
All right,
That's-
you have said that it is included within those.
And that's included. That's your losses will get. All the applicants were selected and appointed as primary teachers against 10% earmarked vacancies as para teachers in the year 2017. Total, my lord, your losses, this data have been supplied to your losses by Justice.
So Mr. Swarnal, tell us if the primary teacher and para teacher is the same,
No, not same.
10% is being cut off from the total vacancy of primary teachers.
Exactly.
If we proceed on that analogy, then how can you say a para teacher is same as primary teacher when your evaluation is different admittedly
But
from
I'm
primary?
not saying para teachers, same teachers. My lord, for
No, your argument was we come within the fold. Why did you prefer leave to appeal? Because you thought by virtue of this judgment we will be affected. Because why? Because from the total 100 vacancies, say 10 vacancies I have been given. Just we are asking you
yes,
this.
yes, certainly agree.
Why do you consider yourself to be identical to those persons indicated in paragraph
Well, I
21?
tell you, look, I'm giving one or two.
Judgment doesn't apply to your case there.
Lord, this is then your losses. Your clarification is needed from your losses. I tell your losses why. 42,000 and odd vacancies.
Right. You are
Total-
right. 42 out of 10%, you are taking 10% primary teacher vacancy for para teacher.
Well, that's not. But total vacancy 42,000, including para teachers vacancies. Now 10,000 odd for trained. Trained have been kept outside the Malad judgment. Then remains 32,000 and odd. Malad learner single judge was 32,000. Then figure has to be corrected. This has to be 28,000 and odd. We are safe. Whenever the learned judge uttered that 32,000, without specifying this excludes Malad 10% para teachers, and it becomes 28,000. If you also specify that 28,000, we are out of it. This is a simple calculation, your lordship. Correction of them. So our case was never represented before the learned single judge either. Then your losses can be considered. Present appeal was taken out by us by application for leave to appeal, and that leave to appeal application was allowed by order dated 18th May 2023. Now I can take your losses to our first ground of the memorandum of appeal. I just read out because it's very difficult to find out the memorandum of appeal. That just now you lordship pointed out that I have not mentioned, we have not mentioned when the appeal was prepared that we should have been kept out of the panel, out of the judgment. That's I just read out the very first ground that the learned single judge has failed to consider and appreciate that the appellants being all para teachers were appointed in the post of assistant teacher in primary schools in the recruitment process of 2016 against 10% earmarked vacancies for para teachers. And consequently, they ought to have been kept outside the controversy raised in the writ petition, and their appointment ought not to have been cancelled.
And you did not refer to the observation made in para 22.
21.
22 of the judgment. Kindly come to that.
22 of the judgment, just
12th of May.
22. Page just a minute, I'm get to page 22. Judgment. The board shall immediately arrange for a recruitment exercise for the candidates who were untrained at the time of recruitment, including candidates who have obtained training qualification in the meantime, within a period of 3 months from the date, only for
Just read slowly. Only for the
candidates who participated.
Up to here it is all right. Where those who participated, where both interview and aptitude test of all examinees shall be taken and videographed. So those who participated in 2016 process were both interview and aptitude test. So this means that the fresh selection which we are going to conduct, according to the learned single judge, you have to take interview and aptitude. If
Therefore, I am excluded. That's your law.
where from you are coming?
Then your losses kindly just before that.
Yes.
In such circumstances, I allow the merit petition, the appointment of all 36,000. Now this is 32,000
No, that is separate.
candidates who were untrained. Kindly see, I was also untrained.
All right. Next.
Then you
Yeah, all right, finished. We understood your.
then just two things your losses to be. That your losses, paragraph 7. Acts as well as laws offer as the selection and appointment of the appellants or parateachers are concerned are entirely different from the
Yes.
selection.
So you yourself, you are taking that down. You are saying that you cannot equate me with them. Terms of selection is different for
Selection because your lordship, there was no aptitude test. That's unclarified, that there was no aptitude test for me.
there was no requirement for aptitude test for that.
That's why your lordship.
All
That's why.
right, this is your argument.
This is my argument.
Thank you. Yes, who is the next senior in line, please? Mr. Ashok Banerjee is there.
Sir, one line in clarification. Neither Mr. Mitro nor Mr. Sanal represents our teachers.
Huh?
They represent without assistant teachers in primary schools or primary teachers who had a para teacher background.
Why background you are saying?
That is a background. We are, by holding the post of para teacher elsewhere for a long period, they had been suffering. Therefore, the government considered it
They
necessary.
have been.
Suffering because they had no fixed scale, etc.
No, we are not concerned with that.
Kindly, just like finish the sentence. They are suffering. Therefore, this reservation is made for them to apply for assistant teacher post in primary schools, and upon such appointment, they become primary teachers like all others. Their present status is a primary teachers. They have lost their para teacher status. They had been para teachers historically, yes, but today they are all primary teachers.
So when they applied,
As para teachers, they were para teachers. They applied as para teachers, appointed as regular teachers. They are primary teachers, having a para teacher historical background. They are no longer donning the robe of para teachers.
so
Yeah,
then
yeah, very lucky.
what meaning does paragraph 22 carry? That you have to hold interview and aptitude for all
Absolutely, yes.
persons.
Then the question is,
That is your argument, but
no,
Mr.
not the previous, not the argument. Kindly see the judgment. The judgment, your lordships are trying to clarify, that if possible, they have to be harmoniously read, 21, 22. But the judge didn't have it in the all. It is absolutely clear from these two paragraphs.
I believe it's a
This non-requirement of aptitude test for this group, that unless that is clarified, the board will be compelled to take again.
did not clarify. Nobody clarified. It was incumbent upon you to say this.
Your lordship, I didn't appear.
Mr. Gupta, is it for us to take that you were just lip tight?
You could
Not say one single thing to the judge.
I will not use the expression, but that was the position.
That is your defense now. that I was not allowed to say anything. Where in your affidavit you have said that you are proceeding on a wrong basis? Show us one.
Where was this question? How did this question come up?
50 times matter was heard.
But how this question was never cropped up?
That is your argument now.
Look,
That is not in your
find
affidavit.
out from the judgment.
Then you should have go back to the trial court and said you have
Kindly find out from the judgment whether any consideration was given to this aspect, or whether nothing was stated in the petition on this.
Now that nobody will speak out and say, you will not tell me that your lordship is not proceeding on that basis. That your there, even if there is a scam.
Provided, my lord, there was a scope for that.
Achha, yes, next, Mr. Banerjee.
Come later on, full now.
So you have anything to add for better teacher?
Yes.
So can you tell us, Mr. Mojumdar, which is your appeal? Yeah, just other Mr. Mojumdar.
Other matters.
Yes, we'll hear. Just we are taking Mojumdar. You are you are appearing for para teachers in para teacher appeal is which one? Mat number.
913 of 2020.
Yes, Mr. Banerjee.
No, my lord.
Item number 41. It's a heterogeneous group of pilot appellants. Some of the appellants in item number 41 are also appellants. This is pilot on. I just say
You
get
please
this
point.
numbers pilot in virus code.
No, we shall take down the note. It is very difficult now we are handling so. So any other appeal where para teachers are part, any of your friends are,
One only, that is item number 40.
you are appearing in that.
Yes. And 74 also that I'm assisting this figure.
That Mr. Mojumdar's matter MAT 913 is item number
74.
item number 70. And Mr. Banerjee, you are for which one is your
Item number 41 today.
mat number?
It's below 1368 of 2023. Which includes some of the.
Which is primary teacher plus para teacher.
Yes, say heterogeneous group.
Yes, Mr.
Should I start, my lord?
Yes, yes.
My mat number 1462. Yes.
Mat number
1462 of 2023. Item number 49. 49, yes.
internal. Yes. We can use it too. Yes,
No, so we will take the trouble to open the papers because I'll be very precise. And I know the court is tired for the last few days going on. So I don't like to put your lordship in further whirlpool by repeating the entire fact once again.
no, we know that. You will not repeat. We know that.
I'm grateful. Right. He has the number of petitioner 237. 237. For obvious reason, I'm saying because I'm not the spokesman of everyone. I'm really concerned about my own headache, own problem. 237. Only 237.
So MAT 1462 has been filed by 230.
237.
You
And they never approach the Supreme Court. They after passing of that order, but they are not included the party. I'll come to that, my lord. We approach the honorable court. They leave to prefer an appeal. That was granted. Yes, that was granted. Yes.
Relief to have been granted by which other?
September 4, 2023. Oh. These are all in admitted positions. There's no problem.
Mr. Rasul Vishwas is 44 appeals now. 44. Please tell us apart the board preferred leave to appeal, board preferred substantial appeal.
237.
And please, can you give the numbers of those MATs where they filed leave to appeal?
All, other than board, all leave to appeal.
Oh, all leave
All
to
leave to appeal, because none of them were party to the
So all the leave to appeals were allowed.
along.
Then Justice Talukdar said that one part of the order is stayed, other part will continue. Against that, who went up in appeal? Board went up in appeal.
Along with 2-3
Along with Mr. Bandopadhyay's client.
Bandopadhyay's client, Mr. Joydeep Kaur's client, and my lord,
So,
one or two.
Please assist us.
I
If
got
you
you.
can give a chart, it becomes easy.
I will. Next day, I'm not, I will.
Yes, what did you say?
No, it's not for court.
No, what did you say?
Sometimes court says something we could not hear. So here also says.
Then we will also say about it.
Always, always.
So the my first point will be, my lord, as we know, the person who's coming to the court or knocking the door of the temple of justice, he must come not only with the clean hand, but with a clean mind. What is the legal right? I could have understood, my lord, that well. It is stated, I was not aware. There's a publications. It was not published in that way that everybody should know. They are participated in the selections. They are all candidate. They participated.